So friends, welcome to the 119th session of Legal Empowerment through Interaction lecture series. The journey continues. My journey of empowerment and interaction. I'm literally in the car. Like Ramkumar said, Ramkumar sir said, literally on the streets. Like today, we have a wonderful speaker, and I like to specially thank Justice Somayajulu sir and also our good friend Vijay for being instrumental in having this program today and getting Dr.N.V.Badarinath sir. He's the presiding officer of the Debt Recovery Tribunal-I in Chennai, and we have a wonderful topic to do with both RDB Act as well as SARFAESI Act, and whether the procedure of recovery under them will have a close examination and I would say incisive discussion on that. We'll have a good interactive session today. As always, we don't waste time on formalities. Directly over to you, sir, Dr. N.V.Badarinath. Thank you.
Thank you. A very good afternoon and namaste to all the participants. I'm grateful to the organizers of this webinar, Mr. Shyampadman and Mr. Vijay, and to my inspiration, Honorable Justice V.V.S. Somayajulu.
Thank you.
High Court of Andhra Pradesh, for providing me the opportunity to have an interaction with this legal fraternity and elite members of this society. Well, before I jump into the topic, because of the time constraint, let me first take you to the overview of these two enactments, namely the presently called RDB Act and the SARFAESI Acts. Well, the phenomenal rise in NPAs and the abnormal delay in obtaining decrees for recovery of the debts due to the banks and financial institutions from the civil courts, and also in executing these decrees through civil courts, necessitated the Government of India to appoint committees like Tiwari Committee, Narasimhan Committee, and also the other high-level committees to suggest a viable alternative mechanism for expeditious adjudication of the claims of the banks and the financial institutions, besides to streamline the recovery process. These committees in chorus have recommended establishment of tribunals. As a result, the act called Recovery of Debts Due to the Banks and Financial Institutions, Act 1993, hereinafter I refer briefly as RDB and FI Act, has come into existence effective from 24/6/1993, thereby ending partially the decades-old practice or procedure of filing the money suits and mortgage suits by the banks and financial institutions in civil courts. Now, the Act, as it stood then, had conferred the jurisdiction on these tribunals to try all the matters involving the monetary claims of the banks and financial institutions, where the sum claim is not is more than 1 lakh, sorry, 10 lakhs, more than 10 lakhs. Now, the tribunal, as defined under the Act, is a single person tribunal to be presided over by the presiding officer, who will be appointed by a notification by the central government. Now, insofar as the adjudication of the claims by the banks and the financial financial institutions are concerned, the tribunal has been conferred to regulate its own procedure. It is stated further that the tribunal is not bound by the Code of Civil Procedure, however, shall be guided by the principles of natural justice and the procedure rules, subject to the provisions of the Act and the rules made thereunder. However, some powers under the Code of Civil Procedure, to the extent indicated under the subclause 2 of Section 22, which are mostly procedural, or summoning the witnesses, receiving the documents or things, were conferred on the tribunal and they can be exercised by the presiding officer. Then the Act also conferred power to grant interim orders like injunction, attachment before judgment, appointing advocate commissioners, receivers, etc. Then the provision for passing an interim recovery certificate whenever the claim is admitted in part or in full by the borrower was also made. Then, in terms of the section 1924, 19 clause 24, it has been stated that every claim has to be disposed of within 180 days from the date of receipt of the application. There is a provision for appealing against the orders made by the presiding officer of the tribunal, and there is also a provision for review of the orders passed by the tribunal. Now, with these brief features, when the Act as it stood, there was a challenge to the constitutional validity of this Act, and ultimately the Honorable Supreme Court of India, in the Union of India and Andhra versus Delhi High Court Bar Association's case, reported in 2009 Supreme Court, page 693, upheld the constitutional validity of this Act. Thereafter, amendments were brought in to this Act with a view to strengthen the teeth of this Act. Then, as a first step, the pecuniary jurisdiction of the tribunal has been raised from rupees 10 lakhs to 20 lakhs, effective from 8/9/2018, enabling the tribunals to focus on high-value matters. The RDB and FI Act, which was the which named the Act was enacted, has been renamed as Recovery of Debts due to Recovery of Debts and Bankruptcy Act. In short, RDB Act 1993. And this amendment had come into effect from 28 May 2016. The renamed Act had brought in several amendments, as I said. I will now cover certain important amendments which are required would help us in today's discussion. Now, the first of the major amendments is disclosure of assets by the borrower other than those assets which have already been mortgaged to the bank. A statutory obligation has been created on the borrower on receipt of summons from the tribunal to disclose all his assets, be that movable or immovable, within the time frame of 30 days. And the Act further said, if willingly any asset is concealed, and if it is established later by the bank that particular asset has been concealed, and then the tribunal can send the person who concealed to civil prison up to a term of 3 months. This is one interesting and very useful provision that we find in the amended provision. Then, the Act also says there is an amendment in the form of 19(4)(a), wherein it is said that the borrower, on receipt of the summons from the tribunal, is prohibited from alienating the properties. Something akin to the demand notice that we find in the SARFAESI Act. But the condition precedent being service of summons on the borrower. Now, this as borrower, as you all know, includes the guarantors as well. Then a provision has been, the earlier provision which we had under 19 subclause 12 for granting of an injunction has been repealed. We are not clearly aware as no reason why it was deleted, but as no reasons were spelled out. That has been repealed. Sub-provision in 19 has been repealed. Now, while these major amendments, the Act which is now we have, now within 9 years after passing this enactment, it has been felt by the government. I quote exactly what the government of India felt. I again say, within 9 years after passing this RDB and RDB Act, originally that's RDB Act, the Government of India, observing that, I quote, our existing legal frame relating to the commercial transactions have not kept pace with the changing commercial practice and financial sector reforms. This has resulted in slow pace of recovery of the defaulting loans and mounting levels of NPAs of banks and financial institutions. By so observing, once again, the government appointed Narasimhan Committee 1, Narasimhan Committee 2, Antarjuna Committee, and these committees have made a fresh recommendation to enact a legislation, a fresh legislation, empowering the banks and financial institutions to take possession of these securities and sell them without the intervention of the court or the tribunals. Perhaps, in fact, this committee felt that only by allowing the banker to take possession of the securities and sell them or manage them, possess them, the speed with which the tribunals are expected to function cannot be expected. Therefore, with this observation, the tribunal submitted its report. Then the report has been accepted, and at another legislation in the same direction called Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, or short SARFAESI Act, has been passed by the Parliament, and the enactment came into force on 21st June 2002. So two enactments within a short period. The first one, the objective is to expedite on the plea that civil courts have delayed, and that experiment, it appears, as can be seen from the purpose of these next committees appointed, had not resulted the expected result. Therefore, another legislation called SARFAESI has been brought in. Now, let me state what are the salient features of this act called SARFAESI Act. As per the recommendation, the act has given power to the creditor. There we call him as a security creditor, because the a security agreement is expected to be created between the borrower and the banker. So we call him the creditor as security creditor. The security creditor has been given power to enforce the securities in the form of sale, physical possession or symbolic possession, managing them, lease them, all kinds of rights that an ordinary owner of the asset would exercise in normal course, almost have been conferred on the officers of the bank, who is called the authorized officer. However, with a rider that he shall follow the provisions of the act without whenever these measures are enforced, as we see from section 13 subclause 1 of the SARFAESI Act. Thus, for the first time, the creditor has been empowered to sell, lease, manage all types of activities which I have just said, insofar as the secured assets are concerned, without the intervention of the court or banks. And remember, the object behind giving it is expeditious disposal of the assets and recovery of the money by disposal. The target is recovery. When asset became non-performing, well, something has to be done with it. So the act said, let the creditor sell them and realize. Whether it achieved its purpose or not, let us decide after the discussion. Then the act also has exempted certain kinds of securities, namely agricultural properties and other items which are covered by situations that are covered by section 31 of the act from being enforced under this act. Now, the act also, the SARFAESI Act also empowered the asset reconstruction recovery companies, asset recovery companies called ARCs, to acquire the financial assets of the banks and financial institutions in the manner provided under section 3 and 5 of the SARFAESI Act. However, under a duly registered assignment agreement. Now, the Act further empowered the ARCs to not only initiate proceedings on their own, but also continue the proceedings which were pending as on the date when the assets were taken over. Now, assets taken over and earlier initiated by the SNR. This SARFAESI Act, also like the RDB Act, underwent several amendments. Adjournment is what is the pet word that we get in the court. So I understand that. See, so it underwent several amendments. In nutshell, these are, for the first time, an opportunity is conferred on the borrower to raise objections in writing or make a statement with regard to the demand notice that has been served on the borrower. And when these objections are made within the time frame in terms of section 13(3)(a), a mandatory obligation is cast on the part of the secured creditor to answer that with reasons. And if the representation is considered, then a fresh demand notice be issued. If not considered, then the creditor shall state the reasons. And the mandatory nature is now one of the salient features of this act, and it's in support of the borrower. Then, however, the act has modified section 13(8), which earlier enabled the borrower to tender the outstanding dues, including the costs and expenses, before the property is put to sale. That right has been taken away by saying that any such act should be done before publication of the sale notice. This is an amendment that we find debatable, whether by this amendment, right to redeem the mortgage, which under the Transfer of Property Act is available till the property is sold and registered, is also taken away, as we do not find any corresponding amendment in the Transfer of Property. It's a debatable, well, not stood at this juncture in my value, but I still maintain that it's a debatable issue. Nevertheless, as on date, if the borrower wants to get his property back, probably he can exercise that right before issuance of the sale notice. Then another important feature is that this act has provided a right to persons who are claiming leasehold rights or the tenancy rights over the secured asset. An amendment to section 17 has been brought in the form of 17(4)(a), and it has laid down a procedure whereby the tenant now is also in the category of a person aggrieved, because section 17 of the SARFAESI Act can be maintained by any person who is aggrieved. It need not be by the borrower or the guarantor. So the tenant has been given a special position in the Act to challenge the enforcement of the security interest insofar as the property which he claims claims tenancy rights in it. So this is one welcome feature. However, the redressal mechanism as it now stood requires further improvement, and some amendments may be needed, which we will discuss a little later. Then the Act also mandates that the security interest, if any created in favor of the borrower, shall be registered with the central registry, lest the authorized officer is precluded from enforcing the security interest in terms of section 26(b) of the Act. Now, the Act also provided for taking symbolic or physical possession of the secured asset from the borrower or the person who is in possession, and thereafter manage, sell, lease out, and do the allied activities, and also a legal obligation to preserve the property in the manner the prudent owner of that property would preserve. Then the constitutional validity of this act also has been challenged before the Supreme Court, ultimately Honorable Supreme Court of India, in Mardia Chemicals versus Union of India and others, reported in 2004, CTC page 759, wherein the Supreme Court, while upholding, the Supreme Court upheld the constitutional validity. However, the provision has to mandatory deposit of 75% of the amount when appeal is preferred against the order of the tribunal before an appellate authority. That has been struck down. So today, we have a different provision, but that provision has been struck down. With that, the constitutional validity of this enactment has been upheld. Now, having briefly discussed about these two enactments, now I shall proceed to discuss the recovery procedure under these two enactments. Though both RDB Act as well as the SARFAESI Act aim at recovery of loans from the defaulting borrowers, there is a difference in the process of recovery. While the RDB Act provides for recovery of a claim or a counterclaim, as the case may be, by adjudication, SARFAESI Act provides for an inquiry by the tribunal as to the adherence or not to the statutory provisions under the Act by the authorized officer while enforcing the security interest in terms of section 13(4) of the Act. Only when said measure is challenged before the tribunal by any person who is aggrieved by the measure. So much so, the tribunal will have no role whatsoever in interfering with the enforcement of the security interest by the authorized officer, until and unless that measure is challenged on the grounds envisaged under section 13(4) of the SARFAESI Act. Then once a challenge is made, yes, the scope of inquiry before the tribunal is wide enough. The tribunal can go into the correctness of the act or the measure that the creditor or the authorized officer has taken under the Act, and in case the tribunal finds that the measure or the act done is not in conformity with the mandatory provisions of the Act and rules made thereunder, the tribunal is empowered to set aside the measure, restore the possession if taken already, be that symbolic or actual, to the borrower or from the person from whom it was taken. So a complete power to restore the possession, set aside the measure, whatever, be that a sale, be that a taking of possession, be that a taking over the management. The tribunal is fully empowered. Then, now, we will now go to the specifics now. Now, before, as I said, adjudication is the process before the tribunal, and finding whether or not the measure is correct is the process to be adopted when a measure is challenged before the tribunal. Let us see what the adjudication process that we have. The chapter 4 of the RDB Act deals with this procedure of filing a claim or a counterclaim and its adjudication. Totally now 6 sections are there, section 19 to 26. These are the vital sections, they are the backbone of the entire Act, wherein we find the procedure as to filing of a claim, the procedure as to adjudication. I know I am addressing the gathering on the premise of, though not all, some of you, that the Act is not efficacious. The topic that is assigned to me is only to decide whether or not. But if someone has the feeling that the Act is not efficacious, so please follow what I'm going to say closely and come back with the questions, right? Well, during the question hour time. So, therefore, the recovery of a debt, which is the focus of today's discussion, is triggered by filing an application, which we call it as OA, original application. And the process is completed when the claim is adjudicated, either ex parte or on merits. And then the amount is settled either by way of an out of tribunal settlement or by the execution of the recovery certificate through the recovery officer. Now, in this process, two important officers are involved. Insofar as the adjudication is concerned, adjudication of claim or counterclaim is concerned, it is the function of the tribunal. Recovery is the recovery of the sum adjudged by the tribunal is the function of the recovery officer. In today's discussion, we are also going to discuss recovery, because efficacious process should always see the fruits of the order passed by the presiding officer as expeditiously as possible. So where the recovery officer has got a very vital role, we will also discuss that. Now, having said that, about the functions of both the presiding officer and the recovery officer, let us see the difference. Now we are proceeding on a topic of recovery under both the enactments. Now, when it comes to SARFAESI Act, for recovery or enforcement for the purpose of recovery, the sine qua non being the classification of the account of the borrower as NPA, less SARFAESI Act cannot be enforced. And still there also, if the 13(2) notice is complied with by the borrower, the matter ends there. No need to go to 13(4). So, but it can't be invoked unless the condition is laid down, like the account becoming the account of the borrower becoming or declaring as NPA takes place. However, insofar as application under 19, original application under 19 is concerned, what is required is, whenever a debt is due, an application can be laid. The debt definition as contained in section 2G of the RDB Act is also covered in the SARFAESI Act. So no need for the borrower to wait till the account becomes NPA, because NPA, the 3 months time for non-payment of interest consecutively or the principal for 3 months, then NPA. But a single default, debt due enough. Remember, the definition of debt is so wide under this act. It need not be the transaction, financial transaction need not be, which resulted in non-payment, need not be between the creditor and the borrower. Can be between any person. Let us see the first sentence in the definition itself. That means any liability inclusive of interest which is claimed as due from any person by a bank or a financial institution, consortium of banks or consortium of financial institutions. So any person is the underlying factor. So if we cannot be under the impression that that means it between the borrower and the lender. So definition is quite wide then. So now, once there is a debt, application under 19 lies. In fact, the very first sentence in the in section 19(1) is for recovery of the debt. The act is also for recovery of the debt, right? So what it requires, it is a very simple procedure. It just requires filing of an application in the format prescribed, verified, like the plaint under order 7 we have a format under the Act which needs to be followed, accompanied by the copies of all the documents relied on in support of the claim. By this is what section 19(1) and 19(3) says. The Act as it stood before it was amended did not insist for filing of any affidavit. Means that it is a simple application. The object is expeditious disposal of cases, total departure from civil code, total departure from civil procedure code. So we are discussing this Act in the backdrop of the object. So for a while, forget about the civil trial. Then now, so what is needed? File an application showing how the amount is jurisdiction limitation. Because in terms of section 24 of the Act, Limitation Act applies. So say that the claim is within limitation, there is a cause of action, and the borrower address, cause title full, cause title small, and then mortgage detail, and then accompany documents, the mortgage document or the statement of account, whatever. That is simple. Now, after that, the next step is the defendant to file a reply statement. Reply statement, unlike any other enactment, the shortest time that has been prescribed, 30 days. Under CPC, I think it is 60 plus 30 days extension can be taken. Here it's only 30 days. And then it further says that if the tribunal is satisfied with the reasons put forth for not filing, another 15 days. So within 45 days, you have to file a reply statement. This was what the initial picture of the Act was. However, after the amendment, a proviso has been added in the form of 10A. I request all the lawyers who are practicing in DRTs, please focus on 10A, 1910A, a very, very important section. Now, 10A has added more life to the recovery procedure, I can say, because hitherto it was not so. We have to find out, search and see how to. Now, what is this 10A? The 10A has said that whenever a plaintiff, whenever a written statement is filed, the same shall be accompanied by an affidavit verifying the contents and declaring them as to be correct. And unless such affidavit is filed, either by the verification is for both applicant and the defendant. The word used is parties before the tribunal. One has to invariably file that, lest there is the case of the applicant or the defendants can be thrown out. Because the tribunal cannot, in my perception, which is based on my understanding of the provisions. So you have a different view, please. I'll invite discussion a little later. So now that 10A, now the 10A is the backbone of the trial. Now what is 10A is an affidavit. So now what we have an application, we have a written statement, we have an affidavit, duly verified. So these three are completed. Then what? Then the tribunal should post the matter for filing admissions and denials of the documents. Admissions and denials of the document is another very, very important provision. And I'm going to tell you by end of the day that if that is not complied with, what will be the problems that you're going to face during the course of the trial if you are seriously contesting a matter. Now, Act has given you an opportunity to state whether you are admitting a particular document or you are denying. Supposing you are denying a mortgage as not executed, or a loan document not executed, or a guarantee document not executed, whether it is registered or unregistered, you need to state in the form of your objections. Otherwise, what will happen? You will know it little later. So, basically, there is a lot of reason behind incorporating the provision called admission and denials. Now tell me, I will also put this later. Keep in mind if denials are not filed by the defendant, because denials by applicant also would arise in case of a counterclaim, not when they claim and defense is put forth. If there is a counterclaim, written statement by the applicant will arise, and the rules of plaint or the OA will apply to the counterclaim, and the rules of written statement will also apply to the written statement of the defendant in the counterclaim. There also, let us see if the admissions and denials are not filed. Can the tribunal take that there is no denial and pass an order? Please reserve your answer. Then what next? You have a application, you have a written statement. Let us say you have a counterclaim, you have a defense to that. In this backdrop, admissions denials are also filed. Now then, what a lawyer in a court or a tribunal would expect is that a fair trial, it is a right. And insofar as the RDB Act is concerned, which is founded on the bedrock of principles of natural justice, has very much provided that. That way it is fully, whatever opportunity given to the applicant is also given to the defendant. If you have anything, yes, we'll get back to that. It is given it. Now, what you expect is, you want to cross-examine. Because in the civil courts, cross-examination is a right. We were, as I also come from Mofassil Bar, where the trial, there was a major activity in trial courts, and we used to take part in trial. And last 30 years, I enjoyed the trial. But trial is what? Chief examination, cross-examination. After 2002 amendment, 18.4 has been, order 18.4 has been brought in, and then it's by way of affidavits and then by way of it. However, in civil court, cross-examination is a right. There is no doubt. But in RDB, it is an exception. Nevertheless, this right is there. Please understand, and if you have, any one of you have any opinion that the right of cross-examination is restricted too much, then it's a misnomer. I'll try to convince you. No doubt, right is not automatic, but nevertheless, you can exercise that right. You can demand an order for a cross-examination legally if you satisfy certain things. Now, let us see what the provision as to cross-examination. There is nothing provided in the Act. We have a DRT procedure rules. Now, these procedure rules done under the subordinate legislation, the Chennai High Court has examined these rules for Philmonia's case and held that they have a force of a statute. Therefore, we take these rules on par with the statute. Now, Rule 12.9, the amended rules now, Rule 12.9 is the provision whereby there is a cross-examination opportunity is discussed. Well, as I said already, it is not a matter of right, but you can exercise that right. How? What it says is, let us see the wording under Rule 12.9. After filing of affidavits by the parties, it appears to the tribunal that either the applicant or the defendant desires production of a witness for cross-examination. Please focus on the first 4 lines. After filing of affidavits by the parties, affidavits, when you are filing? You are filing affidavit along with the application, 10A. You are filing an application. You are filing an affidavit along with the written statement. Now, after filing of the applications, you are also filing your admissions or denials. Now, if from that, please see the first affidavit. After filing of the affidavits by the parties, both sides. See, this is a right available to both sides. By the parties, it appears to the tribunal that either the applicant or the defendant desires production of witness. So the tribunal should be fed with information. You should lay a foundation in the affidavit which would enable the tribunal to first see, yes, here is a case where a cross-examination is required. How you would lay the foundation? Can you lay a foundation in the affidavit without it being there in the plaint or the written statement? Well, if you want to cross-examine a witness, you have to prepare yourself right from the time of filing the OA, and the written statement and the admissions and denials. Because what is not stated in the application or the written statement cannot be put in the proof affidavit or the counter proof affidavit by the parties. So, take for instance, you want to say that the document is obtained by force, coercion, duress, undue influence, or fraud, misrepresentation. These are all things. Now, in fact, these are the standard defenses. Sorry that I'm using standard defenses because, unless you lay a proper foundation for these defenses, you are not entitled to have an opportunity of cross-examination. I tell you why. It is settled law under Order 6, Rule 4 that whenever a plea such as misrepresentation, forgery, the coercion, duress, etc., where a free consent under Section 10 of the Indian Contract Act, one of the facets is that there should be free consent. Is taken, the burden is on the person to prove that. And not only that, it further says the details of that must be pleaded. Now, what is happening today is, in most of the written statements that I come across, I can proudly say that I had the privilege of presiding over 5 out of the 6 debt recovery tribunals in Chennai, wherein I have come across a lot of written statements. Very few written statements contain the details of the pleading. Barring that, most of the written statements only say that signatures were taken on a blank paper, misrepresented. You are putting only the caption of your contention, not the details. You need to have that. If you have those details in your plaint or the written statement, counterclaim or the written statement, they will find place in the affidavit. Then if they find place, let us come back to 12(9). After filing of affidavits by the parties, it appears to the tribunal that the parties desire. Your desire, you need not file a petition in my view. Because I can as a presiding officer, I can formulate my own procedure. Thou had given me. I read it at the very beginning, 22. It is nothing illegal if I orally entertain. Then that apart, under Section 9, tribunal has the power to call for an affidavit from any party to prove a fact. Therefore, no need to file even an application according to me, if you have it. Because Rule 12(9) says, after filing of the affidavits by the parties, it appears to the tribunal that either the applicant or the defendant desires production of the witness for cross-examination. So tell me, who has defeated your rights of cross-examination? Is the statute or the pleadings? Well, you decide. Because if you have enough pleadings, I do not think that rejection of the claim will be most improper to do so. Here again, I would take you to the Delhi High Court Bar Association case, because often this decision is relied on by the applicant whenever a defendant files a petition for cross-examination. And if I am right, the general perception is that the Delhi High Court Bar Association case has restricted further the right to cross-examination. If anyone has that feeling, I'm afraid you may not be right. Because, like many of you, I too have read the judgment. And then when I read it, my understanding of that ruling is, it has enlarged the scope of cross-examination. You may be surprised when I have said it enlarged the scope of cross-examination by applicant or by the defendant. I will now read out the passage where Honorable Supreme Court had the occasion to consider. Now, please allow me to read this. When the High Courts and the Supreme Courts, in exercise of their jurisdiction under Article 226 and Article 32, can decide questions of fact as well as law merely on the basis of documents and affidavits, like in DRT, documents and affidavits filed before it. Ordinarily, there should be no reason why a tribunal, debt recovery tribunal, likewise should not be able to decide the case merely on the basis of documents and affidavits before it. This is the first part. Very rightly, Honorable Supreme Court has compared the decision-making process when it comes to Article 226 or 32 with the process at the tribunal. Because you know the scheme of the Act, for a while forget civil code, because the preamble I read, mounting NPA, abnormal delay, phenomenon rise in the NPA, abnormal delay. So that is taken away. Civil court picture, please for a while take it away. Now what the High Court, Supreme Court said, yes, when we are able to do it, High Court is able to do it. Why not? That is fine. But see the next one. It is tribunal likewise should not be able to decide the case merely on the basis of documents and evidence. Next, it is common knowledge that hardly any transaction with a bank would be oral and without proper documentation, whether in the form of letters or formal agreements. I think it is an accepted fact. Bank lends under a document, demands under the letters, parties exchange letter. It is a common knowledge. We are not going into the proof of them. High Court also, nor Supreme Court also gone into it. It is a common knowledge. It's by documents. There is no oral lending, oral agreement rather, between the banker and the borrower. It is by documentation. We have to accept that, whether we like or not. In such a situation, what in the backdrop of the document, the transaction being documented, in such a situation, the bona fide need for oral examination of a witness should rarely arise. See the wording wonderfully. In a situation where the transaction between the borrower and creditor is documented, the bona fide need for oral examination of a witness, that means we are calling the other witness, come, I'm going to ask you, of a witness should rarely arise. So the Supreme Court is fully conscious of the fact that there are situations where there is a need. That is why I never use the word never arises, rarely arises. Then see the next sentence is far more important. Then there has to be, then the next line is, there has to be a very good reason to hold that affidavits. There has to be a very good reason to hold that affidavits filed before tribunal in such a case would not be sufficient. Means there has to be a very good reason to hold that the affidavits in such case would not be sufficient. Means what? You have to come with the reason. In that, merely by filing affidavit, we can't establish. Where from you get the reason? It is from your application, if you are an applicant. If you are a defendant, from your written statement. So if you have laid a foundation in your written statement, which will be reflected in the affidavit. If you have laid a foundation at the time of admission denials, then it is a good reason, and it is a case where it is an exception. Certainly the tribunal should allow cross-examination. But tell me how many matters one is able to meet this. So Delhi Bar Association case is a double-edged weapon. It is also gives a double advantage, like it gives a disadvantage. Why I'm telling you this is, whenever you are this judgment, if you must have read and you know that I'm not I'm just sharing what I have in my mind. So when a plaint is drafted, sorry, OA is drafted, written statement is drafted, counterclaim is drafted, its reply is drafted, please keep this in mind. Keep in mind 10A affidavit. Keep in mind that you want a person to be cross-examined. Therefore, lay the foundation. If you have laid the foundation and despite that you are denied a right to cross-examination, probably that may not be right, and then you can agitate further. And this Delhi High Court Bar Association case is not an impediment at all. Therefore, please understand now, you have a right to file a chief affidavit, you have a right to admit or deny a document, you have a right of cross-examination. You have then what 1920 says, the tribunal, after giving sufficient opportunity to both parties, shall decide the matter within 30 days thereafter. So now this process of trial, please, for a while, let us go back to the civil trial, which most of us are acquainted with. Now, tell me what is missing in between, except, according to me, except cross-examination as a matter of right. Everything is there. There also you are filing chief affidavit. Now tell me, even in civil, though you have a right, when can you exercise the right? Again, Order 6, Rule 4 strictly applies there. Unless you lay a foundation, the applicant lawyer will say he has not pleaded it. He will stop you there. No need for the judge to stop you. The applicant lawyer will pounce on you. The opposite lawyer will pounce on you, saying this is not pleaded. Facts which are not pleaded. Then what? Then 56 of the Evidence Act, if I am right. Good. And non-traversal under 8.3. I'm sorry, my memory on civil law is not gone not, because I'm totally been kept away from CPC for the last 4.5 years. So what I'm saying is, please forget the provision I may be putting wrongly, but see now compare both. What is the missing factor here? Except that you have to urge. You urge because you have pleaded, you have a right. What if you have pleaded and you are urging? Then what a tribunal can do? How can I give you relief of or leave to cross-examine a witness? Because you have not laid the foundation. Therefore, my perception of the trial, what we call as civil, and the process of recovery here is that both are all the trappings of a civil trial very much present here. Therefore, that only for that limited extent, I feel that the Act had given or made necessary provisions, incorporated necessary provisions, keeping the interests of both sides. This is I'm open for a discussion. But tell me, when I said that the Act is, as far as the procedure part of the Act, for adjudication of the claim under the SARFAESI Act, or finding the correctness or otherwise of the measure initiated to recover the dues under the SARFAESI Act, when it's fine, everything fine, then why the feeling or why the doubt? Or can we say, because both are fairly well set in the Act, the process of recovery is efficacious? Well, if I say efficacious, I think I will just wind up my speech now. But so I'm continuing so you can understand. In my perception, efficacy of a process, efficacy of the enactment does not lie only in providing a good or a decent or a fair procedure. It should also provide a mechanism for expeditious disposal and for realization of the fruits of the decree without delay. Because you all know delay defeats the justice. So we need, in my view, for the limited purpose of today's discussion, efficacy can be judged and certified only when these two facets are coexisting. If one is there, the other is not there, then I'm afraid you judge whether I'm right or wrong. We can't call the process as efficacious. So I have just said about what is the trial. Now let us see the other part. Are we able to dispose of the cases as expeditiously as possible? Leave alone the target. 6-month target is not mandatory. As expeditiously as possible. We are going at, I'm sorry, I would say, don't say we, I'm going at snail's pace. Leave alone meeting these requirements. Why? Why? The efficacy is affected once it is found that the system is slow. You know why I'm telling this? This is accepted. Why? Because you see, again, go back to my submission on overview of these two enactments. CPC is delaying, sorry, civil trial is delaying because CPC contained a lot of provisions to stop, hold, all that. So, no, we don't want that. We want a different. The committee sits, 3 committees, they recommend RDB and FI Act. Within 9 years, it is found by the Government of India that this is not giving the required fruits. So they find yet another enactment called SARFAESI. Now, after 2002, within again 14 years, we have got IBC. Again finding that the system is slow. So what is happening is an enactment is coming after enactment. And the earlier enactment is found to be ineffective. See here, let me deviate a bit and tell with your permission. See this fast tracking of this system, no doubt required. But what is happening is in the process of fast tracking, you are empowering the engine, not the track. So if the speed of the engine is increased without the track being set properly, old track, new engine, what will happen? It will derail. So the fast tracking must be done. The whole of the system, whole of, no, you do both. Otherwise derailment. 2 acts have derailed. Not I am saying, it is by the reports. The third is, of course, doing well now in the for recovery of debts due to the banks and it's a resolution process and all that is different. Therefore, in this scenario, let us see where the track is loose, where the track requires to be repaired, so that we can see that both the facets of a fair and good trial with opportunity to both sides would be available to the parties. Now, one more thing, sorry, I forgot to tell about that trial is, see, Evidence Act, though not made, there is no reference about applicability of the Evidence Act here. But you see, documents are received under Section 3 of the Evidence Act. It's a documentary evidence. Then the documents here are received are the bank statements, the mortgage or loan documents, etc. And electronic documents like statement of accounts, etc. And when it comes to the electronic documents, now it is now they made clear that the 65B class 4 certificate is mandatory. We have the authoritative judgment in the Arjun Pandit Rao's case. This, if anyone is interested, please note down the citation. This 2020 SEC online Supreme Court page 571. So today, the RDB Act is also taking care of the Evidence Act also. If you in the defense, if you plead that 65B class 4 is not complied with by the banker, I cannot look into the document, it's mandatory. So another advantage that the parties have, Evidence Act also, to the limited extent of judging the documentary evidence, has been given. Now, coming back to this, the speed that everyone is expecting. As a defendant, you also expect your matter to be disposed of quickly, so that the outcome, whatever it may be, then you will get rid of the matter and you will get back your whatever the consideration for the services you have done. And then now let us see. So now we will now go back to the issue of the delays. Now let us see what is the first thing here. How can we bring some more life into this act? Firstly, I would suggest, see, you are filing, you means a banker. Some bankers are here, all the respected persons, senior lawyers. There are so many senior distinguished lawyers, retired, current sitting judges of the High Court are also there. I'm grateful to them for their presence. And because of the paucity of time, I'm unable to refer by names. But if I have time, I will try that. Now, let me tell you now why the system is, now there is a feeling that it is inefficacious. Take the stand first, how it starts here. The process of recovery is started when an application is filed by the banker or a financial institution. That is called OA. Now, the OA would lie for a sum over 20 lakhs 1,000 or 20 lakh 1 rupee or 200 crores or 300 crores. In Chennai, we get cases of 4,000, 3,000, 5,000 crores. And major cities may get some more. Some more. Other major cities like Bombay may get even more. So for everything, one yardstick here. Now, see this. Now, undoubtedly, it should be. It should be. There cannot be any difference in adjudicating the claim of 1 rupee or 1 crore. I'm not on that. But I'm telling you why this. Now, when an OA is instituted, don't be under the impression, if you are a banker or a lender, that merely because he defaulted, merely because his account became NPA, and despite opportunity he could not regularize the account, he would not do so until you get a recovery certificate or until you take him to full trial. There are many borrowers who are willing to settle the claims at the threshold, provided some concessions can be given, or even without that also, if some facility to repayment to their comfort is given. I can tell you with my, as I said, having presided over 5 out of the 6 tribunals in Chennai for a reasonably good time. In some DRTs, most of the claims are based on agricultural loans, education loans, MSME loans, housing loans, and the parties are ready to pay. Some of them say, if you reduce the interest, we'll pay. You give me 3 months, we'll pay. But these cases are taken up for hearing after 4 years. And you may be surprised, when I took over the DRT1 Chennai in 2016, I had 32 cases, which were on an average 25 years old. The Act also had not come up by then, because the cases were in the Chennai High Court. Original suits in Chennai High Court were also transferred to DRT after constituting the tribunal. And we had disposed of them with the cooperation of the wonderful bar where I preside. So why these are all? And some of them have settled. Now, when the cases are of different type, now why can't there be a pre-trial or a pre-institutional mediation and settlement of the cases? We can have a system. We can suggest to the lawmakers that let the banker make an application to the tribunal to send summons to the borrower, asking him whether he is willing for a settlement before the claim is instituted. Here you may say that bankers are sending letters, borrowers are not responding. Leave for a while. Is a third party involvement here. The tribunal is going to send that. and it will be mediation by third party, a mediation center, or where there is no mediation center, by the legal services authority or some authority accepted under law within a very limited time frame. And say, then the summons are issued and the party comes and it goes to a mediation center where the same lawyer who is appearing is going to appear for the if contested will also appear. Mediation process is now, it is covered by statute and rules and Supreme Court mediation courts. Therefore, I think with my little experience, I can tell you 50% of the cases will get settled. All kinds of cases, mostly small scale, even major industrial, major borrowers, high value cases also show willingness. But this process is not available in the statute. We have a process under the Commercial Courts Act. Section 12 of the Commercial Courts Act makes it mandatory that in all suits, that is a civil code, in all suits where no urgent orders are required, shall be instituted only after the pre-institution mediation and settlement has taken place. They have to necessarily refer there, then only. But I feel that if we adopt that, there is a problem in so far as original applications filed in DRTs are concerned. Mostly they are accompanied by an application for urgent relief, like attachment or passport, then not to leave the territory, all kinds of things, injunctions, such kind of things. Or if not, to get over that provision, bank may come with an application. So, what verbatim copying that may not be very fruitful. What I am suggesting is, please ponder over this. I can only make a suggestion. If we have a pre-institution or a pre-trial, for example, in an urgent matter where a bank has to obtain an injunction against you, we can't ask the bank to first go to mediation and come back. In such matters also, before we start the trial, we can ask the bank to file a petition. In fact, it should be filed along with the OA, and we will refer it to the mediation center. Let them resolve. If it is settled, fine. Advocate gets the same remuneration. I don't think by adjournments, the fee will also simultaneously get increased. Whatever it may be, it is not in my domain. I'm sorry, I cannot go in. If I made any comment, I take it. What I'm saying is the purpose here is to see that the matter is settled with the mediation of a third party. Bank lok adalats also, many a times defendants or borrowers are not showing much interest because they feel that there is no balance of bargaining. They feel that imbalance. Therefore, one step I feel is to bring back the speed in this. Speed, how I can bring, if the pendency is reduced. The pendency can be reduced. Docket explosion can be averted by pre-trial or pre-institutional mediation. Now the other step that I intend to suggest is the reply statement. The reply statement. You know, as per the existing provision in the RDB Act, I said already, you have 45 days time. 30 days you are entitled from the date of service of summons, and thereafter 15 days, which is the discretion of the court, to be exercised after recording reasons in case it is extended. Now, this written statement, experience shows that it's taking at least 3 to 4 months after service of summons. The delay in service of summons, that is attributable to the applicant or other reasons. That anyhow we can't count. We have to count from the time that the summons are served. Now, once the summons are served, 30 days and then another 50 days. Now, the Act, in terms of Section 1924, the tribunal, as far as practicable, should dispose of the matter in 6 months. Now, 4 months or 5 months time is taking for the reply statement. In fact, in some cases, more than the time. virtually the section became redundant because of the factors which are not in control. Banker also can't be blamed because the address he gives, and that is the address the banker can quote. He may not be able to get the fresh address in all cases. Now, why can't we do one thing to avoid this delay? Because again, I'm telling, please don't look at this process with the lens of a civil trial. You have taken a departure. The moment you are practicing under this act, you are a different lawyer in the tribunal. And the presiding officer is not a judge, because I'm not presiding over a civil court. I'm a creature of a statute and a tribunal. Therefore, that deviation little bit, of course, the other factors that I don't again do, that will be in our mind. Now coming back to this, let us see the provision as to the timeline of filing the reply statement. Now we had a lot of controversy whether it is mandatory even under the CPC to file within that 60 plus 30 days. If not, what to do? Can the suit be decreed if the court is satisfied? And insofar as the RDB Act is concerned, it only says that within 30 days you have to file, if not 15 days. And in case it is extended by another 15 days, totally 45 days. Here also the Act is silent as to the consequences of not filing. When the consequences are not spelled out, it is directory but not mandatory. Now a question before the Supreme Court had come as to whether in a commercial transactions, timeline can be mandatory. Now we are definitely talking about a commercial transactions. Now the Honorable Supreme Court of India in SEG Contracts India Private Limited versus K. Chamakar Infrastructure Private Limited, reported in AIR 2019 Supreme Court, page 2691, upheld that 120 days time available under the Commercial Courts Act, where all commercial transactions is mandatory. Then this matter further taken, this issue once again taken before the Supreme Court in Deshraj versus Balakishan, very recent judgment of the Supreme Court, AR 2020 Supreme Court, page 64. Now, in this, Supreme Court Honorable Chief Justice had categorically held that the timeline for filing reply statement is not applicable to non-commercial matters. Timeline for filing reply statement is not applicable to non-commercial matters. Now, in the bank, the transaction is a commercial transaction. Undoubtedly, the banker charges interest on the commercial rate. It's a commercial matter. It is not nothing short of that. So, why not there be a provision akin to what we have? If not provision, the act can also be invoked. Sorry, the ruling can also be invoked, because that is the law. The Supreme Court. Now, please ponder over. If we have time frame for the reply statement, which will commence after the mediation time. If mediation time is 45 days or 1 month, then we should have 30 days is too low, as we have it's not sufficient. Then another 15 days extension also is not sufficient. Let the time be given like in civil court, 60 plus 30 or some reasonable time. So, but make it mandatory. Make it mandatory so that we can bring more speed to the system, and then in the process, more speed to the process for the process of adjudication. Next, now one more area where I feel is that the mechanism that we have under this Act, whether it is sufficient or leave alone sufficiency, whether it is really catering the legal requirements in certain areas, please ponder over this. I'm not going to pronounce my opinion on it, but I will leave it for you to decide. As I said earlier, today the tribunal can pass an order of attachment before judgment. The proviso is mutatis mutandis Order 38 Rule 5 series. We have in 1913. Injunction has been deleted under 1912. 1912 has been, as I said, it is repeated. Now, attachment, as you all know, when an attachment order is passed, it would come into effect only when the attachment is effected. Unlike an injunction, when it comes to the knowledge, it operates. Attachment requires effecting it. Now, in civil court, we have a nazar, I don't know what it is called elsewhere. A bailiff would go to the spot. Here also the recovery procedure, after recovery certificate, there is a provision and the recovery inspector is doing it. But I am talking on the original side, attachment before judgment. Now, the attachment order, if contested, order pronounced if given, parties will know it. Parties are, we pronounce in the open court, we upload the PDRT, or you are entitled to take certified copies. That's how you get it. But tell me, what, any order of attachment passed by the tribunal is really effective as required? Because 38 Rule 5, as I said, is verbatim copied. It is not, whether it is, where is the bailiff? I don't have a bailiff. And I can't send it to a civil court. I have no power. But the attachment is taken as attachment and then it is continued by the recovery officer. Now, why not we think of a provision? Why can't the legislature take care of this lacuna and suggest what best? To a large extent, in Tamil Nadu, it is safeguarded. In Order 35 Rule 8, Order 38 Rule 5, a provision has been inserted, I think if I am right, is Rule 12, wherein in 2006, it said, wherein it has been said that every order of attachment before judgment, when passed, should be communicated to the concerned SRO, and the concerned SRO should make an entry. As far as Andhra Pradesh is concerned, where I practiced, till I left, there was no provision. I remember we filing petition to communicate this order. Some courts are willing, some are unwilling. Some courts used to say, you are a lawyer, you can communicate. You send it to your letter or in some form as you like. But in Tamil Nadu, there is a clear-cut amendment. But how many states have that? I'm not sure. So why can't the Act have why not the Act itself have a provision? The moment we communicate to the registrar, it is affected. Forget about the bailiff, tom-tom and all that. After all, the purpose here is, the focus is in the loophole. The purpose should be served. So why not the RDB Act contain a provision akin to what we have in the Tamil Nadu local amendment to Order 38 Rule 5 CPC? So that here anyhow I am communicating, because the lawyers are invoking that, we are doing it. Why not the statute says? That will safeguard your interest. Otherwise, it is debatable whether again a fresh attachment has to be obtained after recovery certificate issued before the recovery officer. If this is invalid, void, all kinds of arguments may come. Please ponder over that. I think that would be effective. We are talking about, see, all this I am talking about in the efficacious, making this process efficacious. What if I give an attachment and it is not effective? It is worthless. So efficacy will improve only when all the facets of these areas concerning this are tightened. These loose nuts are tightened. So please ponder over that. That is one area I am thinking that where the efficacy can be increased. Uh, now I will now raise one interesting question before I come to my conclusion part. Right. See what is happening practically with my little experience. I can place before you my view. Remember, a mortgage created in favor of the bank can be enforced through under the RDB Act by filing a recovery claim, recovery application, OA, or through SARFAESI Act. Now, the jurisdictional factors for filing the OA and the SA are not akin. They are different. SA can be in one court, OA can be in another court. Because the cause of action, the jurisdictional factors for both are different. It's not necessarily that you file OA, you should file SA in that court. Because banks are also, lending is from Madurai, SARFAESI notice is from Chennai. So, SARFAESI action will be in Chennai and OA will be in Madurai. Now, and within the Chennai, all the three DRTs, OA will be in DRT 2, SA will be in DRT 1. See, this is all this, they are entitled that way. Now, in this backdrop, please examine one factor. You know, CPC is not made applicable. So, I can follow. In fact, if we see transport, honorable judgment, honorable Supreme Court said, I can go, tribunal can go beyond CPC. I don't know to what extent I can go. Beyond CPC, I can go. But keep in the background the fact that CPC is not made, I'm not bound by CPC. Now, in OA, first OA is filed, mortgage is disputed in the written statement. Defendant says that I have not executed the mortgage. Right. He says it, even if I execute it, it's not valid. Even if it is valid, it's not binding. All kinds of, with all details he takes. Now, meanwhile, the banker files SA. That comes before another tribunal. There also defendant takes a plea that I have not executed mortgage, not valid. You all know that it is set in law that any issue as to mortgage shall be decided by the tribunal. Now, in the SA which I SAs are decided quicker than OAs, or sometimes it is possible that OA. Let us take a situation where the SA in particular tribunal has decided that there is no mortgage, valid mortgage and they dismissed the measure, set aside the measure. Right. Meanwhile, the OA is continuing. In the OA, the tribunal comes to a conclusion that there is a valid mortgage and then orders recovery by sale of the property. Now, there is a conflict between the same parties. One court has taken it. Now, whether res judicata principle can be applied here, I am afraid in the absence. No doubt, res judicata applies to the tribunals if my assessment is correct. It is held in the labor court case. It is applicable. But question is, we are not taking up the CPC here. Now, one DRT decides there is mortgage, one DRT says no. Now, what will be there? There is a conflict. So, how to avoid that? How to avoid that? I don't think under a statute one can say that if the contest is like that, send the same to the other tribunal, unless by way of a transfer application. But we don't even know what is happening, because in that OA one lawyer appears, SA another lawyer appears. Lawyers, if they have knowledge, they will be certainly, they would say. So until the decision is out, one will not be knowing it. That other court also is covered with issue. So how to meet this? How to meet this? In my view, what can be said is that if the issue of mortgage is raised, then both sides will be knowing about it, applicant and then there are two ways. Firstly, the statute must say if it is raised in the OA, it should not be raised in the SA. This decision in the OA or vice versa. Because I tell you, the inquiry in the SA is no way inferior to that of the OA. The reason being, 17.3 says the tribunal, upon receiving the documents and the evidence produced by the parties, shall decide the measure whether it is in accordance with the provisions of the Act or not. There are also evidence, very purposefully the word evidence is not very rarely used in RDB, whereas emphatically, purposefully used under 17. And not only that, the procedure of trial, though not prescribed specifically, inquiry under the SARFAESI Act, 17.7 takes care. It says wherever the provision relating to, in the absence of a provision in SARFAESI Act, we can recon to RDB Act. So again, the same trial. So both are equal. One can't say SCA, though the SCA when arise, SCA will arise only when there is a challenge. That's a different matter. But once it is challenged, both are same as far as the inquiry is concerned. But purpose is different. Purpose is different. Therefore, there should be a mechanism where there should be a declaration stating that issue is mortgage issue is raised by the party. Like in we also there is a provision in the Act. No other case is pending between the same parties in any other. A declaration to that effect, so that when such situation is brought to the notice of the tribunal, there can be a possibility of clubbing the matters, or they can be sent to the other court, or one. Or alternatively, the Act itself can make a provision that the finding as to mortgage given in SC is final and binding on the parties. Then that can be appealed, and finally that's a different issue. Or the finding as to mortgage in the OA is final. Otherwise, this dichotomy is really causing a lot of confusion. Banker cannot do anything. Party who succeeded also is not able to really get the fruits of it, because what is given with one hand is taken away with the other. This is the area where I feel you all should ponder over. Therefore, let us now summarize, because the time constraint. I've taken more time than given to me. I'm just concluding, enabling you to put questions if any you have. Now let us now get back to the overall view of it. This is an enactment passed, taking a complete departure from the civil trial. Initially, it suffered certain setbacks, but amendments had given a new impetus to the Act and teeth to it. What is the fundamental factor here is the tribunal shall observe the principles of natural justice. I am sure that all the parties before the tribunals have no second opinion in saying that yes, the Act has given equal opportunity. Then, Act has given you a right to file your reply statement. Act has given you a right to make a counterclaim. You can also seek a set-off. All kinds of rights that you have in Singapore. Then, Act also has given an opportunity to admit or deny a particular document. And the Act also has given you a right to file an affidavit stating what your case is and what you are praying for. In this backdrop, if you still want a person to be cross-examined, yes, Act has given you the right. The Act has not limited your time for filing the reply statement. You can take time. The Act also has given you a a provision to ask for attachment, ask for advocate commissioner, ask for a receiver, ask for an interim recovery certificate. It's very valuable. Defendant can say, I'm not liable for 50 lakhs, I'm liable for 30 lakhs. Then 30 lakhs can be decided, spot decided, issue an interim recovery certificate. His burden will be for the 20, that can be decided. So everything is there in a, but the problem is that there is no ammunition to trigger the bullet train for achieving the target. That is the area where one need to bestow and then make this Act more efficacious. So with this backdrop, I still leave the question whether or not the recovery process under these two enactments is efficacious or inefficacious to the judgment of the allied members who are present here. I am very grateful that the sitting judges, past judges, senior advocates, one of the senior most in Chennai, Sri.Shyam, whose junior was Justice Satasimam, former Chief Justice of India, also present. Several advocates from various parts, from my hometown and other parts of Tamil Nadu, my home bar and the bar of Chennai, senior lawyers, so many are present. I am really beholden to all of you, and I am grateful to the organizers for giving me the opportunity. Now it is your session. If you wish, you can put your questions. Thank you very much.
Thank you very much, sir, for that really captivating session. In the sense, like all of us were eager to hear and would like to know about the recovery process and the confusions we had. So before we start, go on to the interaction section. May I request the person responsible for your presence today? I would say that Justice Somayajulu, sir.
Thank you, Mr. Badrinath. It was a good lecture. Quite good to hear you. I have one question that is still troubling me.
Yes.
One of the processes of recovery is the sales certificate that is issued by a recovery officer. It is the culmination of the process of recovery. Now, what is the legal status of a sales certificate issued by a authorized officer for a sale? Does it require registration or is it exempt under section 17 of the registration? Particularly the Madras High Court bar, I think somebody should clarify this. See, that is the culmination of the... Now, this is the process by which the sale is effected, the recovery is completed, and let us say I'm an auction purchaser. So I have a little doubt whether authorized officer of a bank is exempted from, is given that special privilege like a civil court or a revenue officer. Either you or anybody else, somebody can clarify. I'll be grateful.
Yeah, I'm prepared, but everyone is there. Please say thereafter I'll join.
Anybody else in the audience may also clarify this.
Okay.
Yeah.
First, recovery officer.
Sir,
Yeah, please go.
Madras, that's why I said Madras lawyers. There is a full bench, I think, to my knowledge. And after that, what happened?
Yeah. Mr. Sethuraman, anyone from Chennai bar? Mr. Ram? I could see someone there.
No, I don't know. That's the host has to decide. Mr. Shyam.
No. I mean, anybody who would like to show, I just unmuted the Dr.N.V.Badarinath, sir. And sir, are you there?
May I take 2 minutes?
Sure, sir.
The suggestion to issue summons at pre-institutional stage or pre-trial stage is really an excellent suggestion, but we have to consider 2-3 aspects. What about the stamp duty to be paid? Because if it is summons to be issued by the tribunal, whether stamp duty is paid as a condition precedent or payment of stamp duty is deferred. If, in my view, if there is some incentive like reduction of stamp duty and reduction of interest and reduction of cost, etc., is there, these pre-trial summons, pre-institutional summons may pick up. That is my view.
Sir, are you referring to court fee?
One?
Are you referring to court fee?
Yes, court fees.
Right.
Some incentive, if there is some incentive, like interest, waiver of interest or waiver of stamp duty, court fees or cost, there may be an incentive for settling the issue at the pre-institutional stage or pre-trial stage.
Yes, you're right. But I tell you, we have a recovery of court fee rules. Recovery tribunal, recovery of court fee rules. There is a provision. The matter is settled before it comes to trial. 50% of the court fee is refundable. Now we can improve upon that, saying if this provision is instituted, naturally, as you suggested, sir, that can be improved by saying that full court fee or the pendability interest, that period, mediation period interest, all can be worked out. It requires, because it's only a suggestion, it has to take a shape. But there is a provision in the Act where the matters are settled before trial, 50% of the court fee we can refund.
Thank you, sir. Thank you.
Justice Somyajulu, your question regarding the sales certificate. Now, the sales certificate can be issued by the recovery officer as he is empowered under the powers conferred on him, both under the RDB Act as well as second schedule of the Income Tax Act. That power is there. Now, coming to the validity of whether it will pass on a appropriate.
No doubt, he will pass on title, whether it requires registration.
Registration. Yes,
Yeah.
it requires registration. It requires registration because for two reasons. Firstly, insofar as Tamil Nadu is concerned, it is mandatory. There is a provision here. Otherwise, elsewhere also. Now an amendment has been brought in, making it mandatory to register the sales certificates.
In Tamil Nadu.
Yes. It is done. But well, to that extent only. Beyond that, it's not there. Yes.
Mr. Vijay.
Yes.
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 Mr. Vijay, other than the Madras full bench, is there anything else?
I think
Can
Madras
we
full
get the
bench
comments
has
of
thoroughly
Ramu
discussed this
Vishnu
particular
sir
issue. I think they have thoroughly discussed this particular issue because they have defined what is a revenue court and what is a recovery officer. Authorized officer cannot be, because the exemption given under section 17 of the Registration Act is to revenue officer, sales done by revenue officers. They have identified, they have made a distinction saying that authorized officer of the bank is not a revenue officer of the government for him to get an exemption of registration.
Yeah, but there is other case law that says that the transfer of title is over the minute the sale is confirmed by the authorized officer or by a, so there is no transfer of title via the sales certificate.
Section 6 of the
That comes up is if the issuance of a sales certificate is merely an administrative act or a clerical act, and there is no transfer of title per se with it.
yes.
Question that is worrying me is, does it require registration? Anyway, anybody else?
I think the sales certificate is basically a administrative compliance of a standard procedure.
Yes.
There is a registration requirement, and registration section 17 provides for registration requirement because there is no distinction between, because he doesn't come under a revenue officer,
Or a civil.
there is section 22 or 23 of the Registration Act which says that within 4 months the document has to be registered. So the time lag between from the date of issuance of sales certificate in real sense is only recognition that he is the highest bidder, and in recognition of it the sales certificate is being issued. So the sales certificate has to be registered for complete transaction. The Madras full bench has gone to the extent that if the registration is not done, there is no transfer of title. That is the observation which they have made in the full bench.
So that is also then an issue that is now has to be clarified. So otherwise, the sale is not completed.
Because they said that there is no transfer of title. The Madras full bench itself
Sir, we
mentioned.
have Jayesh with a.
Yes.
Sir, we have Jayesh with a comment, sir. Jayesh, can you?
Yes, good evening, sir.
Good evening.
Can you hear me?
Yes, sir.
The Madras High Court recently has held that the authorized officer sales certificate has to be registered.
Yes.
And it has to be registered in the value of the guideline, not even in the value of the property sold by the authorized officer. Because at times, property is sold by the authorized officer at a very distressed value. And they say that why should the state government lose its revenue on this stamp duty? The recent judgment of His Lordship Justice Sundaresh J.
Yeah, after the full bench, sir. There was a full bench decision also, sir, on this.
Yeah, now apart from that, there's recent judgment also, which I'm not able to say the citation.
You can
Just
give it
read
to
a few
Shyam,
days back.
but I'll take it from him or anybody. You can give it to Shyam, I'll pick it up.
I will certainly do it, sir.
Definitely, sir. I shall.
Great.
Thank you so much.
Mr. Jayesh
Great
Doria,
with
lawyer, Chennai.
Thank you, sir. Justice Ramushan, sir, can we have your comments?
No, it's a nice presentation on that subject in comparison between the SARFAESI Act as well as the Debt Recovery Tribunal Act. See, even though there is no provision, I think that the Legal Services Act is take care of the pre-trial settlement. Can it not be possible for the tribunal to send for an adalat and settle in the adalat? If such a procedure is adopted, I don't think that there is any difficulty for getting a settlement, out of court settlement, by arranging adalat in consultation with the Legal Services Authority. If that is adopted by the tribunal, because tribunal has got its own power, you can evolve your own procedure for the purpose of advancement of justice. Can it not be possible for you, in coordination with the Legal Service Authority, conduct adalats before the trial is started, so that the settlement could be arrived at? And if I remember correct, there is one provision in the Legal Service Authority Act says, once it is settled in the adalat, you are entitled for full refund of full court fee.
That's fine. We are adopting that method whenever there are requests from the parties. Parties are coming forward saying we will refer the matter to Lok Adalat. But the result that we are getting.
No, even if you send for, even if a provision is there, even if a provision is there, because we are having that experience in the civil court also, the order 10A says, you will have to refer, etc. Matter need not be settled in the mediation also. It may be taken as a ruse for getting an adjournment also sometimes.
True.
The only the persons who are interested in settling it are settling it. Now, all other matters they are not doing, because the banks are coming to court only because they fail in their own banking adalat methods, and further procedures are given for the purpose of settlement and all those things. Even thereafter, if an adalat is passed, they will have to go for execution because they are not honoring the decree sometimes.
That is right.
So the very purpose, probably that may be the reason why SARFAESI Act came, for a summary taking over the property and sell it and realize the amount. RDB, the Debt Recovery Tribunal Act also, though it is not a civil court as such, you have got the trapping of a civil court, you will have to conduct a trial on when there is a disputed questions arises, and you will have to pass an order. Only that order is executable through the recovery officer. So the ordeal of a trial, one way or other, is there in the other act also. Only thing is, the manner in which it will be conducted, how far, etc., is a different question. Even there, if the contested questions are there, same type of parties will have to be examined, documents will have to be produced. If the liberal construction of right to cross-examination is given. So the 6 months period or time limit, etc., though there are number of enactments where that has been provided, it has become redundant because none of the tribunals or none of the courts which are bound to dispose of in a particular period under the statute are not able to do it. Starting from Rent Control Act and the later the NI Act, even the NGT, where 6 months time is provided, sometimes it is possible, sometimes it is not possible. So that difficulty is there where it is provided. So that it becomes what you call a letter in the statute, then it is being enforced in its spirit. That is always there. But as regards these things are concerned, I think that some mechanism can be evolved by the tribunal itself for that purpose. Ultimately, the question is, even if it comes whether they are paying it, you say that the defendants will be able to pay it if some time is granted. Unfortunately, in India is concerned, it is only for the purpose of getting time to postpone the payment, get some time, get a decree, and thereafter the amount is not paid. The bankers have no other, banker or financial, whatever be the decree holder, no other option but to go for execution. Then his headache starts. So that is the thing. So that all those things, it is only we can say that the effective system is get the fruits. How it will be possible unless the honest borrowers are there. For effectively wanted, if some what you call concession is given, they will pay back. The only thing is, are we not providing, because my personal, because as a judge, I have conducted adalats, banking adalats, some interest waivers have been provided by the RBI, etc., etc. Are we not promoting defaulters?
We are.
Because if you honest person who is paying any amount to the bank, if you want to preclosure,
Honest person also requires opportunity.
Everybody knows you will have to pay 1% more.
All right.
For the purpose of pre-closure, this thing, some banks are not realizing it, some banks are doing it. So you will have to pay a pre-closure loan because they are losing interest for a longer period for which the loan has been granted. But at the same time, if this opportunity is given, these people are not only amenable for a settlement or by giving time, and thereafter, I don't think that any of the people have paid the amount and cleared the amount without going for execution. They will have to go for execution again.
No, there are different divergent.
It is not divergent. It is a practical thing I am telling about. It's a practical thing that as a lawyer, as a judge, as a common man, I come to because and having friends with the banking people also. This is the thing that is the attitude of the people. Unless that attitude of the people changes, there is no question of. And because the banks have got their own restrictions regarding the waiver of interest also, because they will have to go by the RBI this thing guidelines as to how far they can waive. One. Secondly, the RBI never allows any settlement in cases where the secured credits are concerned. Because you have got a property, sell it and get it. That is the attitude of the RBI also. Realize the amount as far as possible.
Yes, sir.
That is there, because that is the one thing I find. Because as regards the res judicata aspect, I think that the SARFAESI Act is not a full-fledged trial as you are doing it. It is only a summary procedure. If there is any doubt regarding the transaction, they can say that go to the regular court and get it.
Not summary, sir. 17.3 says that I have to take into consideration the evidence and the documents produced. And it also says that all the provisions of inquiry under the RDB Act also applicable. So we are not doing it summarily. Lawyers are arguing extensively, raising issues.
No, the purpose, it appears that it was one was the summary remedy because they were going for a summary recovery even without a certificate. Even without a certificate. Because here at least recovery certificate is there because you have got a order of recovery amount, settled amount.
Yes.
Or a decree amount due, what is due has been settled on the basis of an inquiry. But under the SARFAESI Act, there is no such provision because you are issuing a notice under section 13. And if the amount is not paid or if the amount is not disputed at that time and subsequent notice was issued, thereafter on that basis subsequent notice was issued, automatically you are going to the forum where it can be filed. Because normally I think Metropolitan Magistrate where you can go for the attachment of the property, the taking possession of the property and sale can be effected to the service provider who has been engaged for that purpose.
Okay.
So I think that I'm considering the nature of the thing, though the full-fledged trial, because even assuming that the Maintenance Act, you are taking full-fledged evidence as in the code of a civil code, but ultimately when it comes to the family code, it is not binding. Similarly, I'm thinking about the nature of the enactment that has been provided for speedy recovery of the amount by SARFAESI Act is all summary in nature. If that be the case, even if it is denied there, a full-fledged finding can be possible in a debt recovery tribunal. Or one. Secondly, bank may be knowing that whether they have filed a OA or not. Even the other party can suppress the fact, but bank may be knowing whether what are all the proceedings they have initiated for recovery of the same thing. Because it is one is not a bar for doing it, because then simultaneously they can go for both.
Yes. Yes.
So the bank can think, suppose if such a question has been arisen, they can withdraw that and they can have their remedy done in the regular procedure code that has been provided in the DRT.
Yes.
So I think that this is my own view of it, because
Yes.
merely because providing some
Badrinath.
amendment etc. is not going to, and as you said, the bullet train, unless the track is proper, it will have its own disaster sometimes. When we created the fast track courts for the purpose of disposal of the criminal cases, what happened? The charges have been provided for the purpose of deciding the cases.
Yes. Okay.
That will be there, because fast tracking is always have its own merits and demerits, depending upon the presiding officer as to how he judiciously disposes of the cases. That much only I can say. Thank you. It's a very good articulation that you have done on the subject, and a good comparison also. You have mentioned the practical aspects where how far it is efficacious or not. Those things are always there, because anyhow, even the Supreme Court and also the legislatures have come to the conclusion that the tribunalization was intended for purpose of a speedy disposal, but that have not achieved its purpose. Any of the tribunals have not achieved that purpose because it has been diverted from these regular civil courts and gone for tribunalization, but that has not achieved its purpose.
Thank you. Yes.
Thank you, sir. Ramesham sir. Yeah, Badarinath sir, please.
Yeah. Any questions?
No. I mean, we were just wondering whether Ramesham sir putting all the defaulters into one compartment and saying that they are always trying to take time.
No, that is no general. No, I am only about. I am not saying there is no.
That may be a bit too much.
No. There is no. I don't say that there is no honest payers also. There are, but majority of them, as a Shyampadmanassociates also knows, Adalat is still settled. Thereafter, when it comes to your execution, they say the Adalat has not properly appreciated and the award cost is not executable. Such a contentions are being taken.
We are not excluding, sir. That is what Krishnaiyer sir said. In the land of Daridra Narayanas, to being poor is not a crime.
Not a crime. That's the I do concede.
Sir,
right, all these things are done at the cost of the taxpayers. That much only I can say. All relaxations given is only cost of the taxpayers.
That of course. We have another question coming up. Yeah, please. Unmute yourself, sir. Yeah, I just unmuted from my end. You'll have to unmute from your end. You are shown us one LLB class, so I don't know your name, so please, sir.
Sir,
yeah,
I'm Satish. I'm Satish from Bangalore. Am I audible to you, sir?
Yes.
You're audible. Please go ahead.
Sir, I'm practicing advocate from Bangalore, Karnataka.
Go ahead.
Dr. Badarinath, sir, your session was fantastic. I have two questions. Question number one is, can 13(3)(a) reply be given by an advocate on behalf of secured creditor? First question. Second question, if secured creditor obtains order under section 14 by fraud, what is the remedy for the borrower?
Yeah, first question. So long as an advocate is properly authorized, he is an agent of the client, he can give. In fact, an identical question came up before the NCLT with regard to the notice to be given for invoking section 7. Supreme Court upheld it. So with the same analogy, I would say that advocate can submit the protest. Now, coming to the order passed by the CMM, even if it is passed fraudulently or in a rightful manner, let me tell you the Act in terms of section 14(3) prohibits challenge before any authority. However, by virtue of the judgment in Noble Kumar's case, a provision has been made wherein Honorable Justice Chelmeshwar had held that it is a measure. Taking possession through magistrate is a measure. So once it is a measure, in terms of section 13(4), the measure has to be challenged, not the act of the magistrate. Because there is no, we are not appellate authorities against the order of the magistrate. You have to challenge the measure fraudulently taken through XYZ. So certainly it can be challenged by virtue of the ruling of Justice Chelmeshwar that the Noble Kumar.
Sir, where it can be challenged, sir?
Only DRT.
The Treasury Tribunal, there is a provision, appeal is provided.
17.
Sir, this authorized officer, if the definition is taken, the advocate on behalf of secured creditor cannot be authorized officer. Then how can he give 13(3)(a) reply?
You can't delegate. No. You are talking about the demand notice. No?
Yeah, for 13(2) demand notice, the 13(3)(a) is the mandatory. Mardia Chemicals. Mardia Chemicals versus Union of India, 13(3)(a) is mandatory from secured creditor to the borrower. For the reply given under section, for the reply given to notice under section 13(2), Now the reply is not given by secured creditor. It is not given by authorized officer. It is given by an advocate on behalf of authorized creditor, authorized officer, which is not valid according to many Supreme Court judgments. I am just asking the clarification from you, sir.
No. If you have a Supreme Court ruling, then you have the correct answer. But let me tell you, if you are referring to 13(2) demand notice, it is issued by the creditor. Authorized officer will not come into the picture until the 60 days period given mandatory is completed. Till thereafter only the authorized officer. So if the secured creditor wants to give 13(2) notice, right, it can be given by the secured creditor himself, or if there is a proper due and a due delegation, yes, it can be given by on behalf of the secured creditor by an advocate. There is no bar. And secondly, any number of 13(2) can be given. We have got a certain law on that, and then the mandatory nature is decided not in the Mardia Chemicals but in ITC Glucose case by the Supreme Court. Right? Yes.
Thank you, sir. We have a CSK Satish with a question. Satish, please go ahead.
Yes.
Sir, good evening, sir.
Good evening, Mr. Satish.
Thank you for your wonderful session, sir. As usual, it was very enlightening, thought-provoking, and you have made us to think on various issues. Sir, I wish to share two thoughts and put you one query. Sir, as far as the issue of that registration of the sales certificates, my senior Mr. Jayesh informed about the decision of Honorable Division Bench of our Madras High Court. Sir, Honorable Judges appearing in the panel also gave their view. I would place before the enlightened audience and you, sir, regarding one issue which is somewhat analogous to that matter. Sir, one issue came before Honorable High Court on the same subject, whether a sales certificate has to be registered and it attracts stamp duty in respect of the documents executed by official liquidator. Here we were talking about the sales certificate issued through Honorable DRT. There the issue came was whether it should be registered and stamp duty has to be paid by the document executed by the official liquidator. That was decided in 2010 2 CTC 113. By his lordship.
2010?
Sir, it is 2010 2 CTC 113, sir.
Okay.
That is a judgment of His Lordship Honorable Justice V. Ramasubramaniam J. It is judgment of Honorable Ramasubramaniam J, where His Lordship comments the judgment itself saying that it is an unusual case, where the application was titled Re the Official Liquidator High Court Madras. The cost title itself is a Re Official Liquidator High Court Madras, and His Lordship, sir, considering all the issues, His Lordship concluded saying that as far as the sale executed by the official liquidator is concerned, the official liquidator should put on notice to the purchaser saying that the sale certificate would attract stamp duty and it has to be registered. Sir, because there was a common misnomer prevailing among the auction purchaser at that point of time, that if a sales deed is executed in your favor, it has to be registered and stamp duty has to be paid. Whereas, in case it is a sales certificate, it is not required. His Lordship dispelled that misconception. And His Lordship also gave a suggestion to the official liquidator that in future, if official liquidator is called upon to execute a sales certificate, the official liquidator shall also put auction purchaser on notice that if they do not pay stamp duty and do not choose to have document registered, it may become inadmissible. This is one aspect, sir, I wish to place before our learned audience and the honorable judges. That is one aspect, sir. As far as the second aspect, sir, regarding that order passed by the honorable DRT under order 38, attachment, our learned presiding officer was pleased to bring to the notice the law prevailing in Tamil Nadu, that it has to be communicated to the sub-registrar. Sir, incidentally, I came across one judgment of our Honorable Kerala Division Bench, where, if I am wrong, sir, I request the learned enlightened audience as well as the honorable judges to correct me, that I don't think that even the Kerala, the Order 38 Rule 5 has not been amended. There seems to be no provision
mandating that order of attachment should be communicated. In that situation, I come across 2015 1 KLT.
Yes, KLT page.
Page 564. I would repeat, sir. 2015 1 KLT 564. That is the judgment of their lordships, Honorable Justice P. N. Ravindran and Honorable Justice P. B. Suresh Kumar. The cause title is Subramanian versus Padmaja. There, their lordships have found the difficulty, and their lordships have also considered an earlier judgment of the Honorable Kerala High Court. And in this particular judgment, their lordships have invoked the inherent power. Their lordships have invoked their inherent power, saying that the registrar should register that in Book 1 of the Registration Act to prevent in future any problem. So that I would place before, I would just wish to share the thoughts before the learned audience. Sir, my query with you, sir, is the topic we have addressed today is whether SARFAESI and DRT is inefficacious and require a relook. Sir, my specific query is, sir, now at the time of inception of this SARFAESI Act, we had only one central enactment, that is RDB Act. So naturally, sir, when SARFAESI came into force, it was looking more attractive, and the inclination of the financial institutions were to move through SARFAESI because they, at that point of time, they thought it is efficacious. Sir, now, sir, after 2016, IBC has come into the picture. Insolvency and Bankruptcy Code.
Yes.
That is applicable only to public companies. That is companies incorporated under Companies Act. Sir, I solicit your views, sir, regarding what would be the significance of IBC, or I will put it a different way. In light of the enactment of IBC 2016, how far these both laws are now efficacious, sir? I seek your views, sir. Thank you, sir.
Yes. Yeah, as of now, the only provisions of the IBC code are not being made applicable to the tribunal constituted under this RDB Act. Right? Now we are only entertaining the matters pertaining to the personal guarantors. And as of now, the DRT 1 has not received even a single application. When I was presiding over DRT 2, I received one application and we registered it. They have not pursued it further. So we are yet to test what would be the approach is under the Act. What would be the effect of that on the efficacy of the tribunal in discharging its functions? Nevertheless, any challenge has to be met. Any challenge has to be met. And over the course of the time, probably we will be finding solutions to that also. And the process of adjudication remains same. There cannot be much change. Nevertheless, since I haven't tested it, I had no occasion to deal with it so far, except registering one application. It's not proper for me to say anything on it. If I get,
sir, I think my question is premature, sir. My question is premature. Thank you, sir. Thank you. Thank you, sir. Thank you.
Yes.
Thank you very much, Mr. Satish. We have Gudla Ramesh. Ramesh, please. Ramesh, sir.
Yes, sir.
Come on.
Yeah, Mr. Ramesh.
Hello, sir. Good evening, Mr. Badrizi and Justice Swamiyazlu and the rest of participants. Actually, it's a very nice session. I have interacted. In fact, there are two questions. Some NBFCs, they are, while filing Section 14 petitions, instead of filing OA, they are approaching arbitration somewhere else. Is it correct on their part? I think SARFAESI is the overriding effect with the rest of the acts. number one. My second question is, some banks are declaring accounts retrospectively. Is it a valid declaration of NPA?
Yeah, Mr. Ramesh, your first question is,
Yeah.
as far as the arbitration is concerned, if the agreement, there is any
Pardon?
agreement, the borrower and the lender contains an arbitration clause,
Yeah.
certainly the matter can be arbitrated. There is a full bench judgment of the Delhi High Court, decided over by Justice Kaur, in the PFC Bank's case, wherein his lordship was pleased to discuss in detail and said they can go simultaneously, hand in hand, simultaneously. There is no bar.
During pendency of section 14,
Section
already
14,
warrant is issued. Yes. SARFAESI section 14 initiated, warrant is issued. At that juncture, they have filed arbitration.
without taking full facts, if you say that when section 14 is pending, then they go. I don't think there will be any bar. Section 14 is only for a limited purpose, taking
course.
physical possession.
Yes.
Physical possession of
Assistance.
property through the magistrate or the chief judicial magistrate,
Collector.
the district magistrate, or the CJM in the recent judgment.
Yes.
So both are independent. This can be done. Straight away, once a demand, see, for condition precedent for 14 is issuance of a valid 13(2). Please see what is required under 14. A valid demand notice and not complied. Then go to 14. You need not even go to symbolic possession notice. Also not be need not be. 13(4) need not be followed. Straight 14 can go. That is what Noble Kumar. 3 modes.
Yes.
So both are.
No.
Arbitration can be. Need not file OA. Yes, that is said.
What I strongly feel is because it is a overriding effect. SARFAESI Act is overriding effect of all the rest of the acts. I don't think they can go simultaneously.
No. See, even if you see the definition of debt, arbitral accord is also covered. See, an award that can be enforced. See, here they are taking possession. Maybe you can raise an objection for the sale. That is a different aspect. Whether recovery is, but taking possession is separate action. They can keep the possession, safeguard it, or they can sell and later take the possession. These are all.
So for recovery, they need not file OA. They can as well go for arbitration.
I can send you two judgments in the relegate case also. Relegate finance.
I think in
2 cases.
consumer court also this principle is there. In consumer forum also people go to consumer forum as well as arbitration. That's been upheld by Supreme Court.
That is, Vijay, because of section 3, the act is not in the act is in addition to and not in derogation to any other act. Section 3 in the old act and section 100 in the new act.
Okay.
Sir, thank you, Ramesh sir. Now we'll Pandurangan sir, you wanted to add something?
No, sir, no.
Thank you. We just saw your comment in the box. So I think TMA, Sai Krishnan, I think your doubt is also cleared. It was regarding registration. Fine. Dilip sir, can you just unmute and put the question? Yes, go ahead.
Sir, good evening, sir. Good evening,
Yes.
sir.
Good evening.
My doubts are with regard to the SARFAESI Act.
Yes.
In Kerala, the Cooperative Societies Act is invoked, and cooperative societies are also entitled to bring action under SARFAESI Act. And when in a case of a cooperative society which had already initiated an arbitration proceeding and an award has been passed settling the amounts due, can the bank thereafter, after years, proceed with measures under SARFAESI Act on a fanciful amount other than what is settled by the arbitration award? That is one of my questions.
See, there are two different. One is, if you are talking about recovery proceedings,
Yes.
that is for purely recovery of the money, like an OA or a proceeding before a cooperative tribunal, either to when the jurisdiction is not conferred on the tribunal. Coming to SARFAESI is an enforcement of the measure. sorry,
Yes.
security interest,
Yes.
enforcement of a security interest for realization of that money.
Yes.
So both are separate proceedings. Here under SARFAESI, you are enforcing the mortgage if created, which is called security interest by way of a security agreement between banker and the borrower. So why is enforcing that? To realize the money? The money is crystallized or may not be crystallized. If it is crystallized to an award of an arbitrator or any forum, it is fine because debt is covered. The definition of debt covers that. If it
Yes.
is not crystallized, then
Yes.
the demand notice amount is already there. You can dispute that under 33A. Is not correct. You can raise that again in the SCA. There will be some finding on it.
My question is, there can be simultaneous proceedings between.
Yes, it will be done.
It is simultaneous, but once it is settled and the dues are crystallized, specified as this amount is due as per this loan transaction, and after years the bank comes with the SARFAESI Act by issuing a demand notice for a fanciful amount.
Then, see, then it is a different contest. Then you can take the plea of limitations as already accord and satisfaction, and all kinds of things. Those pleas can be taken in that. That's the factual matrix. Maybe in your case, warrant contest. Anyhow, there will be demand notice 13(2) to you in that case. SARFAESI means 13(2) is mandatory. You can contest that. At the threshold.
But on what ground?
No, Dilip, I think that once 13 notice is issued, you have got an opportunity to challenge the quantum of the amount.
Yes.
Once you challenge that is amount is not due really, because there is already a crystallized amount as per the award, then automatically they will have to the answer for that. Otherwise, the authority whom, that is a metropolitan magistrate or the chief judicial magistrate, will go into the question and say the amount claimed is not correct, so it cannot be.
Ramakrishnan sir, I am aware of that. But if the bank, yes.
Authorized, see, under section 14, there is no scope to verify the correctness of the amount. But under 13(2), when demand notice is given to you, claiming some amount under the award or some calculation, you have a right to make objections. If the objections are not considered, you can make them as grounds in the SCA, and the tribunal is bound to decide that. You have a mechanism clear.
But by the time the SA is filed, say there is no provision for SA against notice under 13(2).
Okay, that's a different matter. Then you can say
only against measures taken under section 13(4). That
Correct.
So we cannot, and rejection of our objection cannot be a ground for SA.
No, it's not. Rejection means you can raise it again in the SCA.
Yes, but by that time the damages will all be done, because section 14 application might have actual physical possession would have been taken, and the parties left with no remedy.
Yes.
To approach the tribunal. So
Yes.
there are cases where, especially in Kerala, where Kerala's cooperative societies are, and the societies normally move for arbitration proceeding, and an award is passed, and keeping it aside for years.
No, you can put limitation. Section 24 is there. You can plead limitation.
Of course, limitation for a suit for mortgage, suit upon mortgage.
No, even under the SARFAESI Act, you can plead debt recoverable as per law. The definition of debt as given in the RDB is also mutant same. Recoverable under law.
Under law.
It's not recoverable. You take at the threshold the objection, then contest the SCA as a preliminary point. Then
I know, sir. SA can be filed only against a measure taken under section 13(4). Against 13(2), there is no provision to file SA.
That's right.
So wait. But by that time, they can definitely approach the police even without recourse to CJM or the metropolitan magistrate. They can actually take physical possession.
Right.
So the plight of the borrower.
Correct. I agree with you. Your grievance is that straight away they are going to magistrate and taking an order. But I'm telling you, even before they go to magistrate, they have to invariably issue a 13.2. Without 13.2, 14 is not maintainable. I would agree with you that before magistrate, you have no right of audience. Right from
Not only magistrates, before the DRT also. Before the DRT also, I am remediless under if notice. If a notice alone is sent under section 13.2.
You have
asking me to pay the entire and also you said for your consideration for proceeding under section 13.4, the 13.2 demand notice must be served, and within 60 days the borrower ought not have paid the full amount demanded in the notice. That is what is gives rise to measures under section 13.4. But under section 14, when filing an application, the authorized officer should file an affidavit saying that I have served the 13.2 notice. He has not paid any amount. Then only section 14 is applicable, not the full amount. But being an administrative order or being a proceeding which has the effect of only an administrative order,
yes,
the CJM cannot go into that fact.
Certainly.
So physical possession will be taken, forcibly taken.
You challenge that before DRT.
When? Against what? Against what? Section 14 is only pending. How can I challenge?
Please see Noble Kumar's case. Against 14 measure, 14 is taken it as a measure. And once it is a measure, it comes under 17.1. Any measure can be taken.
Yes.
Noble Kumar once again. Still, if you have doubt, yes, we'll discuss it again.
then one more aspect. One more aspect regarding the sale. See, suppose possession is taken, physical possession is taken. After years, it is not brought to sale and no amount is recovered. After years, the bank goes on adding the interest and costs for every month, and interest on interest also, penal interest also, and then comes up at the fag end of the limitation period for selling the property under e-auction. Can that delay or unreasonable delay caused at the hands of the secured creditor be a ground for vitiating the proceedings? I mean, vitiating the SARFAESI sale done.
When you challenge that measure of sale under 17,
yes,
and if you succeed, and the tribunal sets aside the measure of sale, a section called section 19 is there, enabling awarding compensation. But Act also has taken care of. Once a measure is set aside as being not in conformity with the mandatory provisions of the Act, the tribunal can also award compensation. Maybe you can bring your case under. Especially because
without interruption, there is no mandatory provision saying that sale should be done within such time after taking.
All right.
So, can I just briefly interrupt?
Yes.
See, your question was about the delay and can the bank which has caused the delay claim interest?
Yes.
Am I right?
Not only the interest.
Whatever.
The depreciation in the value of the asset.
Whatever it is.
Building, if it is taken possession of.
Okay. A person who commits a default cannot take advantage of his own wrong. He commits there is a Supreme Court judgment under the arbitration law, you will get it, which said a person who is responsible for the delay or the failure cannot claim interest for that period. Very clear judgments of the Supreme Court are there. You will have to bring your case within that.
Whether the borrower has reasonable grounds for the default, if at all.
No. It will not vitiate the entire proceeding. Maybe they can scale down the amount due.
No, the sale has been said to be taken place after years when the 12 years period is going to be, and it was taken possession of somewhat 10 years before.
That is what I'm saying, sir. If there is a delay on the part of the bank in the culmination of the proceedings, they cannot take advantage of their wrong. And the delay.
And one more question with regard to the reserve price. See, section 13.5 says if there is no bidders for a reserve price fixed for an auction for a particular reserve price fixed, there is no sale could not take place for want of bidders. Then the authorized officer shall adjourn the sale for 2 days within 15 after 15 days.
Yes.
After 15 days, and upon a resale being auction being conducted, and then also there are no bidders, the bank can bid in their favor in its name. But if upon cancelling a sale or not taking place of a sale by want of bidders on first instance, the bank automatically cuts the reserve price as half the price already made, and years after or after a considerable lapse of period moves another e-auction for a reserve price which is half of the original reserve price, and the bank directly bids it's in favor in violation of section 13.5.
It's a good ground to challenge.
Yeah, good ground. Are you sharing your any case facts now?
No.
All the best.
Actually, no. My attempt is I have come across so many cases where
Right.
this is
Right.
These because the bank is at their whims and fancies proceeding with, and they won't even resort to the RDB
They are
proceeding.
extreme aberration.
And also a person who has to file a securitization application for a person, he has to pay court fee for the fans, the amount claimed by the securitator, not for the amount settled. See, in an arbitration, suppose the amount is settled, and so after that the essay is produced. The demanded amount in under section 13.2, on that basis, the court fee has to be paid in essay.
Yes.
So these are all.
These are
all grounds which I say, according to me, makes the SARFAESI Act oppressive against the borrower.
Yes. That's right. It's a straight case. Yes.
Well, we have
and also one second.
Go ahead. Sorry.
See, the limitation for filing section 17 application is securitization application is 45 days. But there is dichotomy of decisions from different high courts. In Kerala, they cannot be condoned. Tribunal is not entitled to condone under section 5 of the Limitation Act. Limitation Act is not made. Is not excluded from application also. But other high courts have said that section 5 is applicable.
Yes, I can tell you this. I held that section 5 is applicable in a case that conducted before me. The division bench of the Chennai High Court set aside my order, saying that it being an original proceeding, Securitization Act proceedings, Limitation Act cannot be applied and time cannot be extended beyond 45 days. Thereafter, I stopped passing because it is a division bench judgment of the Chennai High Court. Even though in my order I have quoted the rulings of the Supreme Court.
Yes.
He followed that. But after some time, another case where I passed a similar order also came up before the Honorable Division Bench of the Chennai High Court. And Chennai High Court upheld my contention and said, which is subsequent to the earlier Division Bench, saying that Limitation Act is applicable. See, we find an excellent clue for this from the judgment of Justice Rama Subramanian, as his lordship then was in Chennai.
Yes. Yes, but where?
And today, Chennai High Court, Chandigarh High Court, Delhi High Court, Rajasthan High Court, Calcutta High Court, I think majority of the high courts are of the view that the delay can be condoned. However, the matter is now in Supreme Court, we have to wait. Yes.
But for a person affected by a judgment of DRT Kerala should come to Chennai.
No. I think that this matter will have to. get the attention of the Supreme Court so that we'll have a uniform thing for the entire country.
Yes,
That
we
is-
hope we hope that Supreme Court will say.
Absolutely. Thank you, Dilip sir. Thank you, Dilip sir, for the interruption. May I just request Ratnam ma'am, please? You can.
Yes.
Go ahead.
Is it my chance?
Yeah, definitely.
No, sir. Thank you, sir. Thank you for enlightening us, Millard, on different aspects of the SARFAESI Act and DRT Act. You know, Millard, my query is, Millard, whether declaring an account as NPA with retrospective effect is a statutorily valid NPA.
Yes. As far as declaration of NPA is concerned, there are norms framed by the Reserve Bank of India. And as far as the norms that have come across till date, there is no norm enabling the declaration of NPA retrospect.
In our case, as the borrower could not establish the education institution as per the loan conditions, after even though he is paying the installments regularly, that account is declared NPA with retrospective effect of the 6 months or back. So back to that. This thing.
Yes.
Is it a valid one?
See, you have
Can the
under 13(2) when amount is claimed, you can, because NPA is a factor for invoking SARFAESI. But if they have not invoked SARFAESI and filed a OA, then the NPA is insignificant because it's only a debt due that is enough. But if your measure is taken under the SARFAESI by declaring the NPA retrospectively or anything contrary to the guidelines of the RBI, you are entitled to contest. And the tribunal is empowered to go into that very much. And we will set at naught in case. After all, to prove the correctness or otherwise of NPA, the borrower is also having ammunition. If you are paying it and there is no 3 months consecutive default, your payment you are making it. You have your bank statement. You have proof of your mode of payment. You can produce that. Say in your reply, these are the things. Stop further proceeding. Despite strong evidence, if the creditor concludes that you have defaulted and initiates the measure, you have a good case before the tribunal, and you can certainly place all this.
our NPA is not for default of payments of installments. Our NPA is for non-establishing that education institution as per the loan conditions.
The terms and conditions, umpteen clauses will be there. Somewhere some clause changes any default. See, basically, if you go by that formula of 3 months default in principal or the interest, then for that you will have the material. If you have paid consecutively for 3 months interest or principal, whatever is payable as per your agreement, then you can put that evidence and say it has not become NPA. Unless it is NPA, you can't issue 32. That would be the defense. Any wrongful declaration of NPA, yes, it is within the domain of to adjudge or adjudicate or
Thank you, sir, for that explanation.
Yes.
Sir, we were missing out on the comments of Justice V. Ramkumar, sir. Can we have
Come back. Come back now.
We saw you back.
come back, sir.
Delay is condoned, sir.
Thank you. Thank you.
Focus.
So delay can be condoned. Section 5 is applicable.
Yes,
Section
that's
5
fine.
applicable.
That
Okay.
is
Thank you.
your control. Fine. Yes, sir.
So your comments, sir.
My comments.
Yeah, of course.
No comments.
No, presumably an excellent articulation, leaving no doubt for no room for any doubt, and whatever volley of queries which were fired at him have been clearly, very, very convincingly answered. Wonderful lecture.
Thank you, sir. Before we conclude, we have 2 more questions. Rajeshwari, ma'am, please, can you unmute and put the question first? We are running short of time and my battery is also running low.
Oh, my God, that is a grave problem.
because when you're on the road, you cannot just recharge. Please, ma'am, go ahead.
Sir, it was a very good session, of course, and we were all very much enlightened. I just wanted to respond to two of the queries made by our friends. I was a banker actually. Regarding this classification of NPA, see, it is not the bank's fault for classifying on a retrospective date, sir. Actually, what happens is the bank classifies the account based on the RBI guidelines. And after this statutory audit or this RBI audit, if they find that the default date is much prior to the date of NPA, that is the 90 days period had not started recently, but it has started much before, just 2 years back or so, then they predate the date of NPA. It is not actually the banks are doing. That is why I just wanted to say that it is based on the audit and the record of recovery made in the account. Sometimes after making some recovery, the bankers upgrade the account. Then after that, what happens again? The default occurs and NPA date changes. But the authority, the auditors and all, they predate it, saying that it was not actually an account to be upgraded that time. That is the reason that the dates change. So I think bankers should not be punished for this.
There is a
That is one submission. And pardon, sir. And one more, yes, sir. One more. Another friend asked for when the bankers are participating in the bids based on this provisions under the SARFAESI Act, they have an upper hand. They reduce the reserve price grossly and purchase the property. Actually, again, public notice is given for that sale of the properties. So if the borrower has got a better buyer, like buyer with a higher price, it is always open to them to bring the buyer and bid the property. So that it was actually questioned before Madras High Court, and Madras High Court has given a judgment. I think it was in Lakshmi Vilas Bank case, and court upheld the purchase made by the banker unless there is any fraud or there is notice period is not proper or there is any irregularity under the act. Because after giving notice, as per the statute, the sale takes place. So borrower or the guarantor, they have got a right to bring a buyer if they are able to get a buyer for a better price, sir.
Thank you, Rajeshwari ma'am, for defending the bank so that we are even. We have seen both sides of it.
Whether she is from Punjab National Bank?
No, sir. No.
From Chennai. Chennai.
Yes, I am from Chennai.
Oh, you are from Chennai because I know one Rajeshwari from Punjab National Bank.
Yes, sir. I am not Rajeshwari from PNB. Sir, actually, sir, only one question. How many times for the same property stay can be granted by the DRT under SARFAESI Act? Sometimes it happens that many times the borrowers approach the DRT under SARFAESI Act to get stay, and every time they get a stay, it happens sometimes. So how it is there any special check in DRT like that?
Every time an irregularity is brought to the notice of court, it has to interfere. So
no,
as long
once
as
a
you
stay
don't commit any irregularity, no stay will be there.
No, sir. When we go for sale, what happens? Yes, when we go for sale, they get a stay. Again, the stay is vacated. Again, we go for sale. Again, on some other ground, they get a stay. So it happens, no? That is why.
Whenever there is a case made out for stay, it will be granted. So it is for you to ensure that no case for stay is made out. It is not the number of times. It is the departure from the statute, if any, or other conditions that are considered for the purpose of granting stay. Yes, they will be considered and granted stay. So always stay depends upon the merits of the contentions and not on other considerations.
Yes, sir. Actually, now I am a practicing lawyer in Chennai, ex-banker.
You might also help us out, poor borrowers at times.
Yes, sure, sir. Definitely.
Thank you, Rajeshwari ma'am.
I'll be much happy. Yes, sir.
Thank you very much. Over to you, Prem.
Well, sir, it was an enlightening. I'm audible, right?
Yeah, sure.
Yes, sir. Yes.
It was absolutely an enlightening talk. At the same time, Vijay, I think you referred to the Tyagarajan's judgment, right? Of the Madras Full Bench.
Right, Madras Full Bench.
Referring to the Tyagarajan's judgment award. Yeah, it was Tyagarajan by Chief Justice.
No, Thalai
Which,
Ramani, Ramani judgment. 2000 Thalai Ramani judgment.
Exactly, which differentiates between revenue officer and a civil officer.
Yes,
Right.
yes.
And in that particular judgment, this official liquidator's judgment of 2010 that has already been considered. That is number one. Number two, sir, you were referring to a judgment when it was held when the High Courts and the Supreme Court, when the High Courts were having the power under 226 and the Supreme Court under 32 to decide questions of fact and law merely on the basis of documents. And that was comparable to the DRT. Is it the judgment of the Bombay High Court or what?
Yeah, it emanated, and finally I refer to the Delhi Bar Association. Delhi Bar Association case by Supreme Court. Supreme Court has agreed with the Bombay High Court view.
Okay.
That was Bombay High Court. Yes, if you want, I have right now the judgment.
From the Bombay High Court.
So has been recorded in this.
Okay, that is because these sentences, it was in the Bombay High Court judgment, because it was very long back. Bombay High Court had an occasion to say like this, so I was a bit confused. And sir, when we have because one was referring to the Jolly George case, and the last person who had put a question based on that Lakshmi Vilas Bank's case, I just want to point out one thing. When the Supreme Court in Jolly George case went on to say about the word Daridra Narayana. And after that particular incident, an inquiry was conducted by an investigating agency. The Daridra Narayana, he was found to have had more than 350 acres of estate. So what about the second aspect is that
We took Justice Krishna for a ride then.
Yes.
despite the Supreme Court judgment. And number two, I forgot her name. The last person who put the last doubt. She was referring to the Lakshmi Vilas Bank's case, in which the Madras High Court goes on to hold like, of course, the bank can bid. And mind you, the particular manager, his name is Vivekanandan, he was prosecuted under the Prevention of Corruption Act. And I happen to defend him. Anyway, it was a wonderful talk, excellent class. Thank you so much.
Thank you.
So as we come to the end of the 119th session, wherein we had a well-balanced look into the pros and cons on either side, defending bank and also attempts of the grievances of the borrower also being highlighted. I would like to thank the speaker of the day, Dr.N.V.Badarinath, profusely for addressing us, and we hope to see you more on this platform, not just as a speaker, but also as a participant, so that we can have exchange of ideas, thoughts, and we'll also get enriched by your wisdom. And thank you, Mr. Somayajulu, sir, once again for.
Welcome.
I'm thanking you so that we'll get more such good speakers, sir.
3 more shortlisted, you will get it.
Oh, yes.
Oh, wow. Thank you very much, sir.
Any
And
brokerage? Any brokerage?
Thank you, Justice Ramkumar, sir. Justice Ramushan, sir. Yes, Ramkumar, sir, sorry.
Thank you so much, sir. Good night, sir. Good night, everyone.
Good night. Good night.
And thank you, all of you. Vijay, thank you. Yes, sir.
Drive safely now.
All the senior advocates and advocates of Chennai Bar, do be part of this journey so that we can share and we can also be enriched by your wisdom, your thoughts and your ideas also. Be part of this, and all those participants from different states, including Andhra Pradesh and all of you. Thank you very much as we come to the end of the 119th session. Till we meet again next Friday. Please.
Shyam, it is your battery or car battery?
No. Anyway, sir, I think with this presentation, myself and the car is getting invigorated. So there is absolutely no issue.
More charged.
Getting charged. Badrinath, sir, once again, thank you very much. And all of you wonderful participants for being there, participating, interacting, and empowering. Thank you. Thank you very much.